The NAACP Legal Defense Fund, or LDF, has worked to protect the rights of Black voters for over 80 years. Founded by Thurgood Marshall, we use litigation, advocacy, and public education to expand democracy, eliminate disparities, and achieve racial justice. We worked for the enactment of the Federal Voting Rights Act of 1965 and have litigated many, if not all, of the most significant seminal cases under that law, including the Supreme Court's most recent opinion and VRA case in Allen v. Milligan. Over the last 2 years, LDF has worked with partners to successfully advocate for the enactment of the New York Voting Rights Act and the Connecticut Voting Rights Act, and we're currently collaborating with robust coalitions of civil and voting rights advocates seeking to advance similar laws in Minnesota, New Jersey, Maryland, and of course, our strong support for this important work here in Michigan. This landmark legislation will affirm Michigan's place as a national leader on voting rights. We submitted detailed written testimony, and today my colleague Martin and I will take a few minutes to briefly highlight several of the most important and significant provisions in SB 401 in particular. But first, I'd like to take a few minutes to just provide some background and grounding on the Federal Voting Rights Act, because that's so relevant to the conversation we're having here today. The federal VRA is often considered the most effective civil rights law in our nation's history. It contains many important provisions, but I'll focus in particular on Section 2 of the Federal Voting Rights Act, which is the core nationwide protection against racial discrimination in voting. Section 2 of the Federal Voting Rights Act permits two categories of legal claims: racial discrimination against vote dilution and race-based voter suppression. Unlawful racial vote dilution can be seen in a few different types of scenarios. It can happen when at-large elections drown out the voices of voters of color at the local level. That's when you have an election structure without wards or districts, so every single voter within that locality votes for every member of the local government's legislative body. Imagine, for example, you have a local government, a town or a city, that's 70% white and 30% black. And white voters tend to vote as a block for certain candidates, and as a result, because of the at-large structure, black voters are entirely shut out of having any representation in their local government because white voters consistently vote as a block to deny black voters any opportunity to elect candidates of choice. The federal VRA's prohibition on vote dilution can also be used to deal with discriminatory redistricting plans. So imagine, for instance, you have a local county commission map and there's a black community that's significant enough to have one representative on that county commission, but the black community could be cracked into two separate districts and paired with white communities, and as a result, that black community is unable to elect a candidate of their choice in either of those districts. These are some of the scenarios that the Federal Voting Rights Act has long been used to combat in federal court, and having this law in place provides a deterrent and rules of the road so that policymakers and local governments don't engage in vote dilution. Unlawful voter suppression, the other category of conduct covered by Section 2, that's a broad category. It can include any action that denies voters of color an equal opportunity to cast their ballots. Take, for instance, a polling place closure in a black community, forcing black voters to have to travel especially far distances to be able to cast their ballots, or wait in longer lines at a fewer number of polling places in that community. Or, for instance, a voter purge that disproportionately affects and targets voters of color. Section 2 of the Voting Rights Act has long been the primary tool to protect voters of color against these forms of racial discrimination in voting and many other forms of racial discrimination in voting. Unfortunately, the Supreme Court and federal courts have substantially weakened the Federal Voting Rights Act, especially in the last decade. This landmark law continues to face threats in courts today. Proving a vote dilution claim in federal court requires plaintiffs to meet a multi-part test that typically requires extensive and very expensive expert analysis. And in a 2021 opinion, the Supreme Court made voter suppression claims more challenging to establish by instructing courts to consider factors that distract from the core question of whether a practice is racially discriminatory. Federal voting rights cases are extremely expensive and often require years to reach resolution. Here in Michigan, for instance, in the face of a federal Section 2 lawsuit challenging the at-large elections in the city of East Point, the city estimated it would cost over $1 million to litigate that case. In a recent case in New York, a school district defending a federal Section 2 lawsuit concerning its at-large elections paid more than $7 million to its own lawyers to defend the case and had to pay another $4 million to plaintiffs after they lost. The Supreme Court has gutted the Voting Rights Act in other ways too, as Reverend Dr. Anthony discussed and President White discussed. In a 2013 opinion, the Supreme Court incapacitated key provisions that require jurisdictions with a history of racial discrimination in voting, including, I'll note, 2 jurisdictions here in Michigan, to get pre-approval from the Department of Justice or a federal court before they can make changes to their voting procedures. So the Michigan Voting Rights Act, SB 401, represents a crucial response to the weakening of the Federal Voting Rights Act and the ongoing threats to black voters and other voters of color. It brings together powerful measures adapted both from the Federal Voting Rights Act as well as other state VRAs to root out racial discrimination in voting. Sections 7 and 9 of the bill provide a state-level prohibition on racial vote dilution and racial voter suppression, similar to the protections that have long been covered by Section 2 of the Federal Voting Rights Act. But, like other state VRAs, the language in these provisions is clarified and streamlined and updated so that litigation under these provisions is more efficient, more predictable, and less expensive than cases under the Federal Voting Rights Act. The Michigan Voting Rights Act, modeled on similar provisions in other state VRAs, also include provisions to facilitate resolution of potential violations out of court and without litigation. Section 13 in particular contains these important notification and safe harbor provisions, which require prospective plaintiffs to send a letter to a local government in writing before they are allowed to sue, and gives local governments a safe harbor to fix a potential violation. These provisions incentivize voters and local governments to resolve potential violations amicably, collaboratively, and outside of court. And we know that they work from practice and precedent in other state VRAs at incentivizing voluntary resolution outside of court. The point is not to create new litigation. The point is to bring people together to the table to prevent problems and to prevent racial discrimination in voting. So at this point, I'd like to turn it over to my colleague Martin to discuss a few other key provisions of SB 401, and then we'd be delighted to take any questions.
Thank you, committee chair and committee members. My name is Martin Harris. I'm a policy associate with the NAACP Legal Defense Fund. Section 20 requires notice of voting-related changes by local governments before they can take effect. This provision applies to a defined set of voting-related changes, including, among other things, changes to polling location, district boundaries, or to the method of election used by local government. This policy provision will help prevent racially discriminatory policies or practices from being implemented without scrutiny by ensuring that the public is notified before changes go into effect. It will enable parties to seek to resolve disputes and prevent potential unlawful racial discrimination in voting before changes take effect. Section 23, subsection 2, provides a remedial judicial pre-approval process to allow courts to require judicial pre-approval before voting changes can go into effect in local governments that have violated voting rights laws. When a court orders pre-approval as part of the remedy to a violation, this provision will require local governments to demonstrate that proposed changes to their voting rights rules will neither diminish the opportunity of voters of color to participate and elect candidates of their choice, nor violate the Michigan Voting Rights Act. This provision will empower courts to prevent new violations from taking effect for up to 10 years after an initial violation in a particular local government. These procedures will serve as a remedy to protect voters of color without the need for additional litigation. Once a local government is part of the judicial pre-approval process, instead of placing the burden on voters to prove that the local government has violated the Michigan Voting Rights Act, the local government would bear the burden of proof when seeking to implement a new voting-related policy. Finally, Section 5 enshrines a democracy canon into state law by instructing judges to interpret laws and rules in pro-voter, pro-democracy ways whenever reasonably possible. This ensures that courts will construe elections and voting laws, including the Michigan Voting Rights Act, in favor of protecting the rights of voters, and ensuring voters of color have equitable access to fully participate in the electoral process. Since 2018, state voting rights acts have been passed in Washington, Oregon, Virginia, New York, and Connecticut. Other states such as Minnesota, New Jersey, and Maryland are seriously considering similar legislation. Within those 5 states that have recently enacted a state voting rights act, we have only seen 5 lawsuits. 4 that were filed in New York and 1 in Washington state. The purpose of these bills is to solve discrimination efficiently, not to facilitate litigation. But where there is a violation, it is crucial that states provide these important protections in a streamlined way to address them. And passage of a state voting rights act will have an important deterrent effect and enshrined provisions to prevent new violations from occurring in the first instance. Enshrining these provisions into law will further strengthen Michigan's democracy for all voters and ensure that voters of color have robust protections. Thank you for the opportunity to testify on this very important bill, and we're happy to take any questions that you have. Thank you.
Thank you very much. Questions or comments from committee members? All right, thank you very much.